I'll give you a nice outline of sort of what we're going to talk about today, and this will give you an overview of the webinar overall. So I'd just kind of like to talk about how we recognise the right to special education and how special education has been implemented in New Zealand. Some of the issues that consistently come back to us from people that are supporting special needs students in the community, and from a lot of the anecdotal reports we receive on our advice line is there are allegations around support and the funding that's provided for special education students, and some of the issues that arise from that, and also how students with special needs are facing discipline in school as well. So just as a starting point, international law is pretty important when we're talking about the right to special education. The Universal Declaration of Human Rights in 1948 set out that education is a basic human right. The International Covenant on Economic, Social Rights, and also the International Covenant on Civil and Political Rights, really important international conventions that have been building up this general right over the years. And the right to education was recognised in that. And one of the key international conventions which relates specifically to young people and the right to education is the United Nations Convention on the Rights of the Child, otherwise known as UNCROC. So UNCROC was really clear in setting out the right of a child to education, the right of a child to determine one's own position in life, so for instance culturally, respect for culture, respect for autonomy and respect for personal space and all those sorts of things, the right to privacy and all the rest. So the right to education for children was enshrined in that particular convention, and the United Nations discrimination in education in 1960s, another important one, because quite clearly set out that where a student has got special educational needs, they can't be discriminated against in an educational context. So that's sort of all the background stuff leading up to the most important international convention that I really want to draw your attention to is this one. So the United Nations Convention on the Rights of Persons with Disabilities, quite a recent convention, ratified by the New Zealand government in 2008. The key article that I would draw your attention to, if you're ever supporting a young person and you need to sort of advocate for them and point out that there's a protection of this right in international law as well as domestic law, Article 24 is the key article that you probably want to point to. The article sets out there are really clear obligations on state parties who have signed up to the convention. And it sets out this concept of reasonable accommodation. So reasonable accommodation essentially means that the student with special educational needs to be accommodated in a way that ensures that they're reasonably accommodated to the best possible measures within the mainstream school setting to ensure that they achieve an education that's equal or comparable to peers that don't have special educational needs. So there's a lot of key concepts in there. So reasonable means that obviously if it would mean $4 million just for one student, it's probably not going to be reasonable. But a lot of the commentary from the United Nations committees has indicated that states should be using available resources to ensure realisation of this concept. So it's just not good enough to say that we'd rather divert the budget elsewhere. The international commentators and those on the committees have said, well, states need to be making an effort to ensure that they're applying as many resources as they can divert to it in the best possible way to ensure that this happens. And a lot of this also flows from a change and a sea change in a lot of attitudes. And so it used to be that special education was considered the other, children were put into special schools and they were separated. Nowadays there's a different emphasis on mainstreaming and inclusion. So the idea being that special needs students can be included in the mainstream, and because of being included, they should be reasonably accommodated in that mainstream setting with other students. So essentially, if you want to read a bit more about it, Article 24 talks a lot about some of the specific details and obligations on state parties, and Article 2 has a very broad definition of reasonable accommodation. It hasn't really been considered in detail exactly what that would mean. So does it mean, X number of extra teacher hours, or, provision of X amount of technology for a particular child? There's never been a specific enough definition to tell you exactly what reasonable accommodation looks like in a particular circumstance, but there is some case law that's developing overseas, and certainly there's a lot more commentary and policy coming out around the ideas of reasonable accommodation. So it's sort of one of those developing areas. And yeah, I guess some of you might have heard about the case which IHC has been taking in respect of the argument of special needs students needing to be better reasonably accommodated in the mainstream schooling system, and where that's got to is it's just ongoing in terms of discussions about what reasonable accommodation would mean. What has the United Nations said about all of this? They basically said that children with special educational needs are entitled to be integrated in the mainstream settings, and they should be adequately supported. So there is not only international law that informs this right and provides for the strength of this right in the country, but also domestic law itself, which has been enacted by Parliament. So in New Zealand, the primary piece of legislation is the Education Act 1989. Sections 3, 8 and 9 are the key sections when you're talking about a right to special education. So the people that tuned into our earlier webinar on the right to education will remember Section 3 talked about the fact that all children between the ages of 5 and 19 are entitled to enrolment in their local in-zone school. And you'll remember I talked a little bit about Section 8, which says that people who have special educational needs, whether because of disability or otherwise, have the same rights to enrol and receive education at state schools as people who do not. And Section 9 is the additional section that follows on from Section 8, which notes that where required, the Secretary of Education can agree with parents of particular provision of special education services. So, for instance, it may be agreed that a particular student needs to go to a special school, and an agreement will be entered into under Section 9 of the Education Act between the parents and the Secretary of Education, agreeing that that student is to attend a special school. So if you're in the position where you're supporting a young person and you're sort of called upon to cite the law that really protects their right to being reasonably accommodated in the classroom or otherwise, the international conventions, in particular the Convention on the Rights of Persons with Disabilities and the Education Act, in particular Section 8, will be your key provisions in Article 24 of that Convention on the Rights of Persons with Disabilities. So as I was saying, under the Education Act, formal agreement is usually required with the Ministry of Education under Section 9 for special educational services for enrolment at a special school. Other related sections include Section 10. So Section 10 is the kind of like review or appeal section of that particular part of the Education Act. So Section 10 sets out a process for review and appeal of decisions made by the Ministry of Education in respect of funding or support. So for instance, what you might have heard of, or supporting young people you might have heard of, a situation where a young person with special educational needs might make an application for high needs support under the ANZASW funding, and I'll talk about this in a little bit more detail to explain what I mean. But there is high needs funding that's available by application, and if that application is turned down, a parent may then appeal under Section 10 the decision with the Ministry of Education. So within a month of being turned down, a parent can ask for a reconsideration. If the parent is still unhappy with the reconsideration, so if the decision is reconsidered, new information or what, other medical evidence or otherwise is presented, and the Ministry of Education still does not think that the child should receive that high needs funding, the parent can then apply for an appeal of that decision under Section 10, and the matter will be sent to an arbitrator. I can talk a bit more about the process in a bit more detail a bit later, but essentially the arbitrator is chosen from a list which the Ministry provides. The parent will then go to arbitration and present submissions as to why they feel their child should receive this support, and the arbitrator will make a decision as to whether or not the child does require this support, or whether or not the ministry decision was appropriate and that the child doesn't meet the criteria. Talk about that in a little bit more detail, but essentially it is quite an arduous process for parents to go through. So if you are in a situation where you're supporting a young person or parents, definitely really helpful for them to have support, and we do give advice on this on our 0800 line as well. So if you ever do run into any issues and there's more of a legal question that you might have, definitely feel free to contact our 0800 line to speak to a duty lawyer. Other relevant bits of New Zealand law that I'd really like to flag here, which will be important just to keep in mind in supporting any young person, are discrimination protection laws. So the New Zealand Bill of Rights 1990 protects people from being discriminated against. So Section 19 sub 1 states that everyone has the right to freedom from discrimination on the grounds set out in the Human Rights Act 1993. So you'll see I've set out there under the Human Rights Act 1993, Section 21 sub H, disability is a prohibited ground of discrimination. And disability is defined very broadly within the Human Rights Act. So that includes physical disability, mental disability, physical impairment, and a number of other things. It's even so wide as to include family status. So one really strange example I could think of for that would be, for instance, if one student has a special needs sibling and that child faces a bar to enrolment because of their special needs sibling, that potentially could be discrimination on the basis of family status. But, a very strange example to sort of point out. But, another one that sort of springs to mind, which you'll remember from the first webinar which we delivered, was, for instance, where a child's parents may not be able to afford the school donation and then they are refused participation in certain schooling activities, potentially could be considered discrimination on the grounds of family status. But it's really kind of a grey area, hasn't really been tested. The United Nations Convention also ensured that there are a lot of domestic legislative policy changes when it was ratified by the New Zealand government. So in the Human Rights Act now, it's now unlawful for any educational establishment to refuse or fail to admit a person by reason of a prohibited ground of discrimination. Section 60 provides some of these educational establishments with an out. An exemption is made where the special services can't reasonably be made available. So if you think back to that example I gave you before, say for example you have a student that is in a wheelchair, but it would cost $4 million to install a lift that would be appropriate to access the relevant parts of the school. There's an English case which has said that in that case something like that would be unreasonable, but particularly where I'm just thinking of this particular case in England. In that case, the operating budget of the school was say $5 million, and it was going to cost $4 million to install the lift. It was just the proportions were unreasonable. But obviously, where it's possible and reasonable for special services to be made available, it will constitute discrimination under the Human Rights Act, arguably, if it isn't done. The key thing about Section 57 is that it falls under Part 2 of the Human Rights Act. So there's a distinction between Part 1 of the Human Rights Act, which is a claim against the public sector or the government crown entity, and Section 2, Part 2 of the Human Rights Act deals with private institutions. So when you're looking at Section 57, that's to do with private institutions. For instance, there was a recent case in the Human Rights Review Tribunal against a private after-school care facility for young children, and the Human Rights Review Tribunal found in that case that the particular care facility for the children had been discriminatory against a student with special needs because they had said he could only attend part of the time there. The parents had to pay extra money for him to be there, and that he could not stay and be picked up at the same time as everyone else. So the Human Rights Review Tribunal found that was clearly in breach of those requirements set out in Part 2, and in particular Section 57, and it was reasonably possible for them to accommodate this young person. It's just that the particular play centre didn't want to. So kind of indicates that this law is all relevant when you're supporting a young person. So not only is it international law, not only is it the Education Act, but also discrimination legislation, and potentially, if there is a breach of that, the school or the preschool centre may find themselves in mediation or in the Human Rights Review Tribunal. There are also policies and guidelines that fill in a bit more detail to the law that I've been talking about. So the Government Disability Strategy document, very detailed one in 2001. It sets out aims for an inclusive society and also notes that where necessary, schools should work with the student and parents to develop an individual education plan for each of their students. Just reminding you back of Section 9 a few slides back, where I talked about the fact that where there's a requirement that a student, for example, attend a special school, there needs to be an agreement under Section 9. Reading into that more of the policy obligations, it would sort of seem to imply that any time you have a student with special educational needs, there's a need to develop an individual education plan. Of course, it's mandatory in cases where a Section 9 agreement has to be put in place, but in any case where any provision of special services is being provided, an individual education plan is vital. So the individual education plan identifies this particular student's learning needs, identifies how those needs are going to be met, a plan and timeline of how the support is going to be implemented and what to do in the event that it doesn't happen. We generally find with a lot of the queries that we get on our 0800 advice line, IEPs are really crucial to good functioning of a relationship between the student and the school and the parents. For example, if there are clear expectations around, for instance, a child with ASD, and for instance in their individual education plan it might set out that they have an extra transition time, or holding on to a tangible object as they transition between classes to help them with the change, or having red cards and yellow cards for stop and go to mediate any sort of stress and anxiety. Things like that, when they're worked into an education plan, can be really helpful to ensure that all school staff are on the same page as parents and the student, and that they're actually working together to ensure that the student has their needs accommodated and can integrate within the mainstream setting. Yeah, so as I said, the IEP is compulsory for students receiving high needs funding, for instance, AWS. I'll talk a little bit about AWS in a few later slides. But, as I sort of said, the school should adapt the school program for learning, and it should contain things like long-term goals, teaching strategies, what specialist services and equipment are needed. So, for instance, a teacher aide is going to be available for X number of hours, and this particular student is going to have assistive technology like an iPad to help them adapt the curriculum. It should also set out the roles for the particular young person's teachers, and ideally, because IEPs are living, growing documents that live and grow as the student lives and grows and the education evolves, they should really be reviewed every 6 months. So what does this mean overall? Like everything I've told you about, no school can discriminate against a child because of their disability. So not only is that through the international conventions, the domestic law, the domestic discrimination law, and government policies, all of that added together means that every child that has special educational needs has a right to be reasonably accommodated in a mainstream school setting, and that they shouldn't be discriminated against or treated differently. What we do hear about quite a lot is where students are being treated differently. So, for instance, they're being told they can only attend part of the school day, or not allowed to attend extracurricular activities, or are being told informally to leave schools. So that can happen. There's been a lot of media coverage around that, with a complaint raised by the IHC just with some of the data that they've collected through surveying a number of their clientele. So essentially, schools are obliged to take all reasonable steps and make all reasonable accommodation to ensure that a child is not disadvantaged because of their disability. So schools are carrying out a state function of providing education. They can't discriminate, and they can't treat children differently in breach of those human rights obligations. So that case that I told you about before with the private preschool care institution, that's the test case that I've cited there. And the court was really clear. They sort of said at the end of their judgment, we all need to work together as a community to support parents and special needs students. And it is reasonable to expect that a private institution like this will accommodate a special needs student. It's no excuse simply to throw their hands up and say it's a little bit difficult. Given that that was, as I said, a Part 2 case, so it was a private entity, the theory of this could really be applied to a public case. So if we're talking about a public school, I think that similar reasoning would likely apply in a public mainstream school, although there hasn't been a case of that. There's only been a case in a private context. So a little bit of history around how the funding of special education is currently administered and how support can be accessed from the Ministry of Education. So there was the introduction of Special Education 2000, quite a while ago now, very early on in the decade, and it sort of had the idea of devolving the provision of special education to local areas. So there was an idea that, there were no longer other students that had special needs that were in other schools, but they were going to be mainstreamed and included in mainstream schools with the other students. Schools were then given a special education grant fund, which is a bulk fund, where schools would apply it to cater for most students with low to moderate needs that did not meet the criteria for high needs funding. So students with high needs would apply for individual funding based on those high needs from the ministry. So said there, individual funding and support was available upon application, as well as early childhood learning support. Relevant people within the school, so if you're supporting a young person, you might hear these terms sort of thrown around, and it's quite good to know what an RTLB is or what a SENCO is. So RTLB is Resource Teacher of Learning and Behaviour. A SENCO is a Special Education Needs Coordinator at a school. So, the RTLBs will be the teachers with the specialist knowledge, sometimes in a cluster that would go to a school and provide that sort of extra resourcing around, for instance, special needs around behaviour. The SENCO would administer and oversee the provision of the support within the school. What we find and what we hear a lot from people that call our advice lines is by default it usually is the deputy principal or someone occupying that 2AC role in schools. So they're always the person to first approach if you're supporting a young person and you want to approach someone in the school regarding the provision of services for a student with special educational needs. Speaking to the SENCO is the first port of call, as they are responsible for overseeing all of that within the school. There are relevant agencies and people within the Ministry of Education as well. So Group Special Education, so the school might contact Group Special Education GSC if, for instance, there's a particular concerning incident regarding a child with special needs or otherwise, or just for general support or assessment of a particular child and their needs. And they'll be working with other agencies as well. So there are a lot of other external agencies which assist with feeding into that. So for instance, if you're dealing with behavioural needs of some particular student, that might involve things such as the Kari Centre or Spelled if you're dealing with dyslexia or anything like that. So working together with all those agencies and having points of contact can be really helpful if you're supporting a young person, because it's usually an integrated approach from various different agencies that is really effective. So as I said, there is the bulk fund, which generally schools apply to meet the low to moderate needs, and where a student might have high needs, they'll make an application for high needs funding through ANZASW, which is the ongoing and reviewable resourcing scheme. And that's
oh no.
Sorry, I can hear someone speaking through the... did someone say that they don't agree with the oars?
Oh, sorry, it's me. I'm Sandra. Sorry, I didn't realise I didn't have it muted, but it isn't reviewable anymore. I work for Special Education. The Ministry.
I keep referring to the old acronym. It used to be ORRS. It's now ORS.
Yeah.
So
yeah,
I do refer to the old one when I revert back. Yeah. But they've dropped the second R now, and the funding is targeted at the top 1% of high needs students. So there's a lot more detail on the ministry website, but essentially there are a number of criteria. So a lot of the applications that you'd probably see for students with behavioural difficulties, for instance, with ASD, might be under Criterion 5, which is to do with cognitive difficulties, or Criterion 8, which is to do with social difficulties. So there's various criteria and various criterion that a student might fall under, and essentially a student needs to make an application under those particular criteria and provide the supporting evidence, whether that's through medical or psychologist evidence, which indicates their eligibility for the criteria. And that's assessed, and then if they are successful, then they then get accepted into the AWS funding scheme, and that has a whole wraparound service. So there's teacher aid, there's psychologist support, and all the rest. Sometimes behaviour can escalate, so there might be the intervention of a crisis team and emergency funding. And setting aside from all that, even though there was an emphasis on mainstreaming, there are still special schools and special units which can be utilised to meet the needs of some particular students who might find that their educational needs are better met in a special school setting. So with the Special Education Grant, or the SEG, that's that bulk fund I was talking about, schools have a wide discretion to spend this. So this includes employing a SENCO, providing training for teachers, additional teacher aid or specialist time, resources and materials. So one example that just springs to mind is, for example, assistive technology. For instance, an iPad for a student that might be able to better adapt the curriculum with something like an iPad. The specialists, the teacher aides, those are the aides that are there to support classroom teachers. So for instance, if you've got a child with special educational needs, the teacher aide may assist the child with activities and manage behaviour. And the RTLBs, they work with children with learning or behavioural difficulties. They're not attached to a specific school generally, they're in a cluster, and they may service a number of schools in that cluster. Specialised teachers also help with visual or hearing impairment. Other specialised services, this is just a quick overview. Obviously a lot more information is available on the ministry website, and obviously you can always, if you need to support a young person in finding out what other support might be available, contact the Ministry of Education. But just some quick examples there: the Early Intervention Service, the Physical Disability Service, the School High Health Needs Fund, Regional Health Schools, Communication Service, Severe Behaviour Service, the Interim Response Fund, the IRF, and this is usually invoked when there's a crisis situation where there's a risk of serious harm. And the Intensive Wraparound Service is a really specific program for a limited period of time, injected into a lot of specialised support, including psychologist support and a comprehensive plan, essentially for a vital point in a student's life where necessary, that sort of targeted intervention. That's decided by a panel, and generally there is sort of a priority list around that. But generally the student has been found to have such high and intensive needs at that particular time that IWS is appropriate. Special schools, at the moment there are both day and residential schools available. The idea is that emphasis is still on inclusion, so it's only really in more exceptional circumstances that the Ministry of Education agrees under Section 9 that a child should attend a special school, because there is this sort of sea change in social context now where we're looking more at inclusion in the mainstream. So what are some of the issues that we hear about on our advice line? So a lot of schools that we deal with, parents that we talk to, they hear things like the schools saying that SEG funding often isn't sufficient to provide for all students with mild to moderate needs, what happens is if a school's doing a really great job, sometimes they tend to attract more students with special educational needs. And because the SEG bulk fund is not calculated on the number of special needs students within a school, rather it's calculated based on the total population of the school and the decile ranking of the school, it means that sometimes schools get overwhelmed with more students because they're doing such an exemplary job that they do struggle to accommodate all these extra students when it hasn't been accounted for in their bulk fund. So we keep hearing a lot of these sorts of themes from people in the sector when they call up for advice or when we're dealing with students who are attending, for instance, disciplinary meetings at school boards. The school boards often report that they feel that the SEG fund isn't sufficient to assist them with covering low to moderate needs, and for instance, the student might not be eligible for the high needs funding. So yes, here we go. So as Sandra said, sorry, I keep referring it to it as the old ORS, which was ORRS, but they've now dropped the extra R, so it's the ongoing resourcing scheme, so it doesn't have reviewable anymore in there. To be eligible, the students need to meet one or more of the ORS criteria. So I talked a little bit about it before, and I'm going to provide a little short summary following, but a lot more detail is found on the Ministry of Education website. So usually when determining whether a student meets criteria, they're compared against a benchmark. So the benchmark is generally an example case of a particular student who has the characteristics that they would expect that student to have for meeting the eligibility for that criteria. So it's quite a long sentence and it's quite wordy, but essentially, you know, for instance, Johnny has autism, Johnny does this, and so there's a number of listed characteristics. A lot of the feedback that we get through the sector, and particularly from organisations like IHC and CCS Disability and the like, is that it's quite difficult to fit neatly within the criteria because each student and each person is different. And also the benchmarks aren't entirely applicable and relevant when you're dealing with such a wide variety of people. It's just a one snapshot of one particular child, but it's not that helpful in assessing eligibility under that criteria. So the criteria have been described as quite prescriptive and quite detailed. Oh, sorry, just go back there. So yeah, you can see there I've laid out some of the criteria. Category 1 is very high learning needs. Category 2 is very high hearing or visual needs. Category 3, very high physical needs. Category 4, high language use, social communication. Category 5, high learning needs. Category 6, high hearing or vision needs. Category 7, high physical needs. And there's a distinction between those, and a lot more detail can be found on the website. But essentially, it differs in the sense of the type of needs that are to be accommodated. Category 8, high language use and social communication needs, and Category 9, combined moderate needs. So rather than having high intense needs, moderate combination of a number of those needs can also mean eligibility under Criterion 9. Really hard for me to sort of give you a lot of detail without actually pointing you to the website and saying a lot more information is available on the website. If you are supporting a young person and they're going through that process, a heck of a lot of information is available on the website about the ins and outs of the criterions. So getting ORS funding, the Ministry of Education suggests applying for ORS at transitional times, from early intervention to school, within the first few years of primary school when it becomes apparent that a student might be lagging, for instance, due to those high learning needs. Where there's a significant increase in needs, so for instance there's clear academic lag and the student's not keeping up with the curriculum and they have high learning needs, and another one might be where they've just arrived from overseas in the country. So as I said before, you know, ORS is intended to fund things like extra teachers, specialists, so for instance, specialist teacher outreach that goes to a number of schools, teacher aids, consumables and resources, so providing a bit more wraparound support as needed for this student with particular high needs. So what we hear criticisms that keep being made that we hear from people are that AWS is targeted at 1%. So at times there are students that are quite deserving that aren't quite making the cut. The criteria is quite narrow and limited. Everyone reports that when they're assisting with the applications, that it's really hard to get a student to fit neatly into the boxes. Often similarities to benchmark examples are a higher indicator of funding rather than actual need, and that's an issue around the problem is that the criteria are quite inflexible, so it's quite hard to apply them to the many different myriad of circumstances that might occur in different students that you would have in front of you. So, and schools are saying, well, our SEG or bulk fund isn't sufficient to accommodate all low to moderate needs that aren't making the cut for the high needs funding. So there are just, a number of students that just in between, they're just slipping through the cracks. So that's some of the stuff that we keep hearing from everyone in the sector about the need for students to have some sort of in between. And I do know that there's been some initiatives that have been introduced, like the in-class support initiative from the ministry and things like that. And there is a review of the Education Act that's been ongoing. And also there was recently an inquiry into dyslexic students and students with special needs. So it's quite good that there's sort of ongoing recognition of the fact that people are raising certain issues around how the criterion are being applied and support for students that may need it. A lot more about this sort of can be found at the website into the review of the Education Act and also the inquiry into special education. So here are some just startling stats which kind of indicate that this is really important. In the 2006 census, 10% of 0 to 14-year-olds had a disability. That's a pretty high percentage, and given like 1 in 10 young people that you support is likely going to have a disability, and it's important to sort of know about the protections that they have and some of the supports that might be available in the educational setting. So I've just put there, for example, issues such as intellectual disability, motor disability, psychological disability, learning disability, ADHD, ODD, autism, dyslexia, and often these things come in a bundle, so you're probably dealing with quite a complex individual in a complex set of circumstances. That's why it's kind of good to work with a number of agencies and know that there is particular points of contact and support available. So I just wanted to give some anecdotes which we receive quite a lot on our 0800 legal advice line, and some of the stuff we hear consistently from IHC and other organisations in the sector. Students with special educational needs are at times being refused enrolment, being kept away for part of the day or being picked up early on the basis the school feels they can't manage the behaviour or the difficulties that stem from the special educational needs, at times being excluded from school camps and activities. So for instance, a particular young person is not allowed to attend the school camp unless a parent is with them at all times, or they just can't attend the school camp at all. Some parents have also been told that they need to pay for more teacher aid time in order for their child to attend at school. At times at the more extreme level, there's been schools saying to parents, well, actually it's just not a good fit. Rather than us take the step of formally excluding your child, why don't you just withdraw or transfer or move into correspondence school? And that's sort of the phenomena known as Kiwi suspension. So you'll remember in our last webinar on student discipline, I talked about the fact that if a school doesn't go through the formal processes which are set out under Section 14, it is in theory illegal and what's known as a Kiwi suspension. So it's not authorised by law, but they've been told to stay away from school. And at the very end of that spectrum is also the fact that schools can sometimes use those Section 14 processes to remove special needs students from the classroom. So punishing them for misbehaviour, although at times that misbehaviour might be related to special needs. And what I would say is, there's probably some concerns around that, as I'll talk a little bit about in the later slide. But if you're punishing a child for their special educational needs behaviour and they haven't been properly or reasonably accommodated, the question is whether or not it's genuine misbehaviour or whether it's the fact that there hasn't been adequate support or accommodation of that student. So I think it's sort of a difficult area, because obviously Section 14, as you remember from the last webinar, is intended to target genuine and willful misbehaviour by students. So if you're dealing with a student that may not be willfully acting out, it's a question around whether or not Section 14 is the appropriate mechanism that the school should be using. So here's just an overview of some of the problems that you might encounter if you're supporting a young person with special educational needs. They likely will have concentration issues or the inability to understand or learning difficulties at times. They might be vulnerable to peer pressure and have communication difficulties. Some of you might be aware of Talking Trouble, which is the organisation which has done a lot of research in this area, and they found that an increasing amount of young people, in particular young people that go on to appear in the criminal justice system, have particular communication difficulties that impinge on their ability to understand and react appropriately in circumstances, which can really impact on their ability not only to function but also in responding to difficult situations which can get them into trouble. So they generally would also have a lack of awareness of safety to self and others. They might have violent or defiant natures, so sort of rigid or quite strict concepts with some ASD students. So IEP plans at schools might include things like easing transition for ASD students, or dealing with violent or defiant exhibition of behaviour that might occur when things change too suddenly or there's a disruption to routine. The real issue is that students with special educational needs are more likely to behave in a manner which the school will find appropriate if you're dealing with, in particular, things like ASD. So a lot more common nowadays for recognition of that, whereas we used to traditionally think of disability as things like blindness, a wheelchair, or deafness, but I think there's more and more increasing recognition and increasing awareness of the fact that symptoms which may be construed as misbehaviour actually may be symptoms of ASD or ADHD or other disabilities which aren't necessarily easily visible, but which may really affect the student's education and learning outcomes. The other thing that often will happen if you are supporting a young person in these situations is that parents are usually very emotional. They've been through a lot, and sometimes they're feeling like they haven't been supported. They're having trouble accessing support from the school or the ministry. So I guess just dealing with the emotional side of things as well is going to be another issue that you might encounter if you're supporting a young person in this situation. As I sort of talked about, it's important that disciplinary action taken is genuine misbehaviour, not where it's due to failure to accommodate and manage a student's special needs. So remember I talked in the earlier slides about reasonable accommodation and international law, and the fact that the United Nations Convention on the Rights of Persons with Disabilities protects that right and says that there's an obligation to reasonably accommodate. If a school is then taking disciplinary action because they're saying, well, we think our SEG grant isn't enough, this child couldn't get high needs funding, we just feel like we're at the end of our tether and we've got no option but to take disciplinary action. If you're supporting that young person, it's open to challenge that disciplinary action on the basis that the appropriate mechanism may be to petition for more support or ensure that the student's reasonable accommodation options have been properly investigated before the school tries to remove them through disciplinary processes. What we do here and what we do know is that special needs students often go through disciplinary processes a number of times, whether that's formally through stand down and suspension over and over again, or informally through Kiwi suspensions and removals and informal agreements with parents that students will just stay away from school where it's difficult to manage their behaviour. It's crucial because it's impinging on their education, it's impinging on their access to education, and the flow-on effects from that and the long-term. And you'll remember from the first webinar we delivered, we talked about long-term effects of students being out of education, the social welfare and criminal justice implications for that is quite concerning. And you remember I talked in the earlier slides about the fact also that if it's treatment like that, where a student is being disciplined because of their special needs behaviour, it may even arguably constitute a breach of the Human Rights Act and the Bill of Rights Act prohibiting discrimination on the grounds of disability. So yeah, just some things to keep in mind. The school will have their arguments in response to that, and obviously they're quite valid ones. So they can't risk harm to other students or staff. There's a lot of new legislation in health and safety and employment which has really strengthened the obligations on schools as employers to provide safe and healthy workplaces. So obviously they need to ensure that their staff are safe, and if they're dealing with a violent or aggressive student, measures need to be put in place to ensure that staff are protected and they don't have their own claims against the school for a lack of safety. Schools do need to maintain a safe physical and emotional environment, and those are in the National Administration guidelines issued by Parliament in terms of what schools are required to do and how they're supposed to deliver public education. There is an exception to the Human Rights Act, Section 60, which I referred to earlier, where it states that if an institute can't reasonably accommodate a particular student, then they're exempted from being found to be breaching the discrimination provisions. So if that is the case, I guess you'd need to show that it isn't reasonable in order to justify that decision. I just sort of have put a note there to the case of, it's actually called A and Hutchinson and others in the High Court in 2014, otherwise known as the case where a student with ASD took a claim to judicially review an exclusion from Green Bay High School. A had ASD, and the school reported during giving evidence to the High Court that the school had petitioned the Ministry of Education for support and assistance to deal with A's particular behavioural difficulties. Some funding was reduced and A's behaviour escalated, and the school felt they didn't really have much choice except to take Section 14 action in respect of A, and A was ultimately excluded from the high school. When the case went to judicial review in the High Court felt that rather than resorting to Section 14 discipline, which was discipline for genuine misbehaviour, it would have been more appropriate to first consider all other options open to what else was possible to reasonably accommodate A before taking that measure. So investigating the relevant background and understanding that actually funding had been reduced, so that was why A's behaviour had deteriorated over that time. So I think the case is really good in terms of just setting out principles and precedents that it's important to ensure that the school is working with the student and the parents to investigate what other options are available to reasonably accommodate before any sort of disciplinary action is taken. If it's been resorted to in the first instance, it probably is not the intended use of Section 14, Section 14 being targeted at genuine misbehaviour. So yeah, hopefully that sort of makes a bit of sense in the overall scheme of things, but I guess there are some wider policy issues that are currently being debated around, how you reasonably accommodate schools that claim that there are some issues with the SEG fund and things like that. So yeah, there's probably going to be some interesting things come out of some of the reviews that are being conducted at the moment, and also we've been researching the area ourselves and intend to publish some of our research in the area as well. And just around that safe physical and emotional environment thing, you'll remember in my Section 14 webinar, I talked about the fact that not only can the school take action for gross misconduct, continual disobedience, but also in serious situations where there's risk of immediate harm and safety to others. But I guess the key thing with that is it's got to be so immediate and pressing that it's justified, not just simply that the school perceives there might be a risk to health and safety, because that probably wouldn't meet the high threshold. So some of our top take-home tips, there's been a lot of information we've tried to cram in here, a lot of stuff about different things like funding structures, the right to education and the right to special education, a lot more detail on a lot of the stuff we talked about, like all the acronyms and terms and technical terms and things. They can be found on the ministry website, so I wouldn't worry too much about absorbing all those things like the OARS criterion and all that sort of stuff. A lot of information is available on their website. But I guess what we would take home from this is that special needs students do need more support. We've heard that there are consistently funding limitations for certain students, for instance, at the very high end, but not quite high enough to meet the high needs funding. Special needs students are often subjected to disciplinary processes and removal from school. And if you are supporting a young person, it's really crucial to support them and ensure the school is acting in accordance with its obligations. The right to special education is really strongly protected in international law, domestic law and government policy. So yeah, if you ever need to refer to those laws, just to support a young person as well in that process. So hopefully you found that useful, and there is a lot of information, so definitely if you do want any further information, it'd be worth having a look at the Ministry of Education website and also our website. If you do want any information from us, here's some more details which we provided in our last webinars as well. Our 0800 number, Monday to Friday, 10 to 4, our website, and our app, which outlines youth rights as well, which is downloadable. As I said at the beginning of the webinar, can everyone please, we'd really appreciate if you could undertake a survey about the webinar just to let us know what you found helpful and what you'd like to know more about in the future. I know that this one was a bit of a flyover and a lot of detail, so hopefully you can get from it some of the main points that we're hoping to convey. And for those that didn't hear at the beginning of the webinar, if there are people that have logged into one computer and there's more than one person, we'd really appreciate if you're able to type your names into the chat box so we have a record of how many people have attended the webinar. I will leave the chat box open just for a few minutes in case anyone's got any questions. I know it's a pretty topical area and there might be some pretty complicated stuff. You can definitely get in contact with us on our 0800 number or on our general email if any questions come to your mind after the webinar. So yeah, I'll just leave the chat box open, and if there are no questions, I'll sign off the chat. Thanks everyone.